Each party will have 15 minutes to present oral argument. The appellant will proceed first and may reserve up to 5 minutes for rebuttal. I will be keeping time, and so if you wish to reserve time for rebuttal, please let me know at the beginning of the argument. And if you would just come to the podium closest to the podium. We've read the briefs and we're ready when you are.
Okay, thank you, Your Honor. May it please the court, counsel for Appellee and my co-counsel. If I could please, Your Honor, I am Attorney John Gager, I'm Law Director for the City of Avon, Ohio. And if I could just give a brief 2-minute introduction, and then my co-counsel, Mr. Stringer, will complete the legal argument here.
That's just fine. Do you wish to reserve time for?
We also wish to reserve 2 minutes.
Very well.
At the end.
Okay.
So let me get into that without any further delay. As I pointed out, I'm John Gager, Law Director for the City of Avon. And with us today in the audience are Mayor Jensen and Council President Craig Witherspoon and Councilman Mary Burgess from the city. I want to just begin by saying that Avon is one of the fastest growing communities in Northeast Ohio. You may or may not know that. We have an abundance of prime, undeveloped commercial and industrial real estate. We have 3 interchanges along Interstate I-90. And we have a unique message to convey to the outside world about the attributes of being in the city of Avon. About 4 years ago, we realized that we need to further convey that message to the outside world, and we thought that we would develop a visitors bureau within the city to further promote economic development, not only in our community, but in Lorain County, within Northeast Ohio, and quite frankly, within the state of Ohio. Businesses come and go. We wanted to make ourselves attractive to businesses that are thinking of moving to Kentucky, moving to Mexico, moving anywhere. As I said, we have an abundance of undeveloped real estate. So a visitors bureau became a very important idea for us, and we checked the statutes. We found that Ohio Revised Code 15CA010879 clearly indicated that the city could add a 3% tax, create a visitors bureau, and use 50% of that tax to fund that visitors bureau. And that is exactly what we did with our ordinance. It was Ordinance 113-14. And we did exactly what the statute allowed us to do. We created the lodging tax of additional 3%, and we want to use that tax now for all of these reasons that I said. I think it's just an economic development driver.
And you are at your 2 minutes if you want to talk.
At that point, Your Honor, I'm going to turn the argument over to Mr. Stringer. Thank you very much.
Your Honors, good morning. May it please the court, Anthony Stringer on behalf of the appellants. The issue before the court is the legality of a hotel tax, a lodging tax that the City of Avon levies on transient hotel guests. It's a 3% tax. 50% of the revenue generated from that tax is used to fund a visitors bureau. The issue turns on the interpretation of Ohio Revised Code Section 15C010879, which states, the legislative authority of a municipal corporation or the Board of Trustees of a township that is not wholly or partly located in a county that has in effect a resolution levying an excise tax pursuant to Division A1 of this section may, by ordinance or resolution, levy an excise tax not to exceed 3% on transactions by which lodging by a hotel is or is to be furnished to transient guests. As I said, the Avon tax at issue is a 3% tax. When it comes to statutory interpretation, this court, in the case Subjob versus City of Talmadge, which is identified in our briefing, stated, when a statute is unambiguous, it is to be applied, not interpreted. To interpret language that is already plain is to legislate, which is not the function of the court. And that, again, is from a decision emanating from the 9th District Court of Appeals. The plain language of the subject statute, 5739, differentiates between municipal corporations on the one hand and townships on the other hand. We have municipal corporations or townships, and then we have a limiting clause that is not wholly or partly located in a county. That is a limiting clause. Under our interpretation of the statute, which we believe is unambiguous, that limiting clause only modifies township. It does not modify municipal corporations. And how do we know this? We know this because there's an important rule of statutory construction called the rule of the last antecedent. Now this is a principle, a rule, that appellees in their brief said is obscure. Well, it's not obscure because the United States Supreme Court, just a couple of months ago, issued a decision where they specifically applied that rule when construing a statute. That case is Lockhart versus United States. We filed a notice of supplemental authority yesterday attaching that case because it was decided after the parties had filed their briefing in this case. In that case, the United States Supreme Court was construing a statute that related to a charge for possession of child pornography. The individual in that case was convicted of child pornography. If you look at the United States Code, there is a minimum maximum sentence of 10 years for that conviction. But if the person had a prior conviction for certain crimes, then that maximum is increased. So if you look at the case, the court had to decide what that meant. And I'm going to read this to you because we believe this case is on point in helping us interpret the statute at issue. A prior conviction under the laws of any states relating to aggravated sexual abuse, or abusive sexual conduct involving a minor or ward. All right, so the issue before the court is, does that limiting clause involving a minor or ward, does that modify each of the three predicate crimes? Does it modify aggravated sexual abuse, and abusive sexual conduct? Or does it only modify the predicate crime that is immediately before it, which is abusive sexual conduct? And the court held that it only modifies the predicate crime immediately before it, which was abusive sexual conduct. And in making that decision, the court relied on the rule of the last antecedent. And here's what the court said about the rule. When this court has interpreted statutes that include a list of terms or phrases followed by a limiting clause, we have typically applied an interpretive strategy called the rule of the last antecedent. The rule provides that a limiting clause or phrase should ordinarily be read as modifying only the noun or phrase that it immediately follows. Now, when we take that rule, which the United States Supreme Court recently applied to a case, and we apply it to our case and the statute at issue, all right, the result is the limiting clause here. Let me just read it again so we know what that limiting clause is. The limiting clause here is wholly or partly located in a county, and it goes on. But that's the limiting clause here. Applying the rule to this statute, that limiting clause can only modify townships. It does not modify municipal corporations. Again, we have municipal corporations or townships. Limiting clause only modifies townships.
And within the context of this appeal, what's the rational distinction between municipal corporation and boards of trustees of a township?
Right. The rational distinction is that throughout the Ohio Revised Code, the General Assembly treats municipal corporations and townships differently. They are entirely different animals. We have Title V of the Code that is devoted solely to townships. We have Title VII of the Code, which is devoted only to municipal corporations. In fact, if you look at the heading of the tax chapter at issue here, it says, it refers to taxes that are levied by counties, municipalities, and townships. So throughout the Revised Code, there's always a distinction made between municipal corporations and townships. So
I
as we look at,
understand the distinction. I guess my question is the rational basis within the context of this statute of distinguishing between a municipal, the legislative authority of a municipal corporation and the legislative authority of the Board of Trustees of a township.
Well, I would submit that the rational basis is that for whatever reason, the General Assembly decided to confer on municipal corporations the power to levy this tax irrespective of whether or not the county levies it versus townships. And again, in order to construe the statute, we've got to go by the plain language of it.
But aren't there cities, aren't there municipal corporations that straddle county lines?
There is, yes, there are, yes, there is, yes.
So are you suggesting then that the part of the city that's not in the county that has the tax could impose it, but the part of the city that isn't that kind of absurd?
The position we're taking, no, the position we're taking is if you're a municipal corporation, you can levy the tax irrespective of where you are in terms of a county line. Because again, the modifying or the limiting clause here only applies to townships. That's how it's written. And why the General Assembly wrote it that way, I don't know. But we have to go by the plain language that the General Assembly used when it drafted the statute. And the court, as I mentioned earlier, is not required to interpret it beyond the plain language, because now we're talking about legislating versus applying the language used by the General Assembly. And on that point, I want to also comment on the Attorney General's amicus brief that was filed in this case. It's worthy of comment. And the comment is, it's not relevant to the issue because we have an unambiguous statute that the court must apply. The Attorney General's, interpretation of it is not relevant because, again, we've got to focus on the actual wording used in the statute. And by the way, if the General Assembly wanted to make this clearer, there's ways to do it. I mean, they could have used the word both so that we have a modifying clause that's referring to both municipal corporations and townships, but they didn't do it here. So again, we just come back to reading the statute, giving the statute the effect based on its plain language, and here the effect is municipal corporations have the power to levy taxes on hotel lodging, irrespective of whether or not the county already has a tax in place. Thank you.
Thank you. You will have 3.5 minutes remaining.
3.5?
Wish to have.
Excellent, thank you.
May it please the court. My name is Felix Wade. I'm here today representing Mr. Evans, who is the immediate past Vice President of the Ohio Association of Convention and Visitors Bureaus. Mr. Evans is a taxpayer, and the Convention and Visitors Bureaus have an interest in whether or not Ohio's taxes under the bed tax statute are proper. It is the burden of any taxing authority to have clear authority for the tax that they impose. We would submit here that not only does the City of Avon not have such clear authority, that the law in fact bars any such tax as imposed by the City of Avon. And I'll walk through that tax code if you will permit. 573902 imposes a sales tax on all retail sales in the state. 3901B1 defines sale to include furnishing of lodgings to transient guests. 715.013 prohibits municipal corporations from imposing a tax that is similar to a tax imposed by the state by, among others, Chapter 5739, unless some other provision of the revised code permits the tax. This is why, when we go pay state sales tax, there's a state tax and a county tax, but there is no municipal tax. 573908 is referred to in the vernacular as the 67 tax. In 1967, the legislature passed this statute and said municipalities and townships can tax transient guests 3%. And they can spend that money on whatever they'd like to. 573908B is referred to as the 79 tax, goes into effect in 1980. It gives the counties a 6-month window. County commissioners, for 6 months, you're the only people that can impose this tax. After 6 months, townships and municipalities can impose this tax. And you can be foreclosed from imposing that tax. And 573909B is the provision referenced by opposing counsel that permits a municipality or township to impose a tax if the county does not already have the tax. Lorain County imposed its tax under 573908 in 1983, long before Avon imposed the tax in question in 2014. Accordingly, Avon's 2014 tax is not authorized by 09B and is therefore preempted by 715.03. It may be complex, but if you follow the dots, it becomes reasonably clear. Now, Avon argues that a law of grammar, not of the state of Ohio, should control your decision and should have controlled Judge Ewer's decision below. We believe that the judge got it right. We think that it is the last bastion where the court should check to see the meaning of the statute. Here, the 67 law lumped municipalities and townships. The 79 law lumped municipalities and townships. And in fact, Judge Moore, to your point earlier, there is no rational distinction here between townships and municipalities. If the City of Avon's argument is correct, there's no limit to the tax that the City of Avon could impose. They chose 3%. Under their interpretation, they could have done 100% because there was no limitation under the statute. That's not really very rationally tied to the purposes of the statute. Avon's reading violates the principle that a statute should be construed to make sense. It does not identify any logical reason why the General Assembly would permit cities to impose taxes free of restriction but not townships, other than the general provisions relating to townships and municipalities in the revised code. We did refer to this as an obscure rule of grammar. Your Honors, this is the late filing of additional authority usually will drive any opposing counsel insane. Blessedly, in this case, it doesn't. The case filed yesterday by the city states in pertinent part, it is a fundamental canon of statutory construction that the words of a statute must be read in their context and with a view to their place in the overall statutory scheme. And they go on to state, more importantly, here the interpretation urged by the rule of the last antecedent is not overcome by other indicia of meaning. To the contrary, the section's context fortifies that meaning that principle commands. So I would submit that the authority cited yesterday in fact supports Mr. Evans' position in this case. In addition to the fact that they could have imposed a 100% tax rather than a 3% tax, the context of the statute clearly reserved for the counties 6 months. When the 79 tax was passed, the counties got this 6-month window. And only the counties could pass the tax in that 6-month window. Now, neither the county didn't, and Avon didn't for quite a while. But what in the world reason could you give the county that 6-month window if the city was really entitled to do it anytime they wanted, to whatever amount they wanted. So, we believe that not only do they not clearly have the authority to pass the tax, we submit that the law is clear that they don't have the authority. They didn't talk about their home rule argument, which was raised late in the case below. It's very disturbing to me to have the home rule argument raised. They have never addressed Ohio Revised Code 715.013. City of Cincinnati, which says there is no implied preemption, is the case they rely on. Well, the Supreme Court in the City of Cincinnati said, if you want to preempt an area, legislature, you better go tell us what you're preempting. So a month later, the legislature, in fast-acting democracy, passed 715, which said specifically that, by the way, the only authority cities, counties, municipalities, cities have is in these areas where we're authorizing you, and 5739 is one of those areas. So we think the home rule argument is just as specious as the underlying argument on the rule of grammar, and we believe that the court below properly held that the statute is invalid.
Thank you.
Thank you very much for your time. Appreciate it.
Sir, Your Honor, 3 minutes on rebuttal?
3 minutes and 28 seconds.
All right. May I split that with my co-counsel, Mr. Gager?
It's up to you.
Yes, I'll just split that with this. Thank you.
How much time did you want to?
I'll take a minute, and I'll reserve the 2.5 minutes for Mr.
Just know that it goes very.
I know it does.
Okay.
I'm going to be quick.
All right.
First, I want to state there is a limit. This is important. There is a limitation to what the city can do in terms of levying this hotel tax. If you look at the statute at issue, it says not to exceed 3%. So we can't exceed 3% in levying this tax, and the tax is a 3% tax. So there is a limitation there.
What would the total tax be if your levy is allowed to go through? What would the total bed tax be in Avon?
Right now, the total bed tax is 6%.
What would it be if your thing was allowed to go through?
It's 6%.
Would it be 9%? Would we have 2 in Avon and 1 in Lorain County?
Yes. Correct, Your Honor, yes.
So it'd be a total of 9%.
Total 9% if we include the Lorain County tax, that's right.
But you would include that, that's not.
Oh, absolutely, no, I
So it'd
agree.
be a total of 9 then for the city of Avon.
Total of 9 for the city of Avon,
Okay.
absolutely right, Your Honor. And I guess to conclude my portion of this, I'll just come back to, this really comes down to a straightforward interpretation of a statute that's unambiguous. We really have no ability to go beyond the plain language that the General Assembly used here. So the other side talks about a lot of things that tend to complicate the issue before the court. We view this as a straightforward issue involving statutory construction.
Okay, let me ask a question.
Yes, go ahead, Your Honor.
You're referring to municipal corporations and townships.
Yes.
Can't you also read this as the instruction is to the legislative authority and the Board of Trustees? We're talking to the people who have the ability to levy a tax. We're not talking about the township or the municipal corporation. We're talking about the legislative authority or the Board of Trustees. Those are the bodies that are able to institute the tax. The municipal corporation can't, and the township can't, but the legislative authorities can, and so can the Board of Trustees.
Right.
So isn't that what we're really modifying?
Right, so we have the legislative authority of a municipal corporation, and then we have the Board of Trustees of a township. That is not legally, so again, it comes back to modifying the phrase immediately before the limiting clause, which is townships. So yes, we have legislative authority of a municipal corporation, they can levy the 3%. Then we have the Board of Trustees of a township that is not wholly or partly located in the county. They can levy the 3%. At this time, I'd like to, how much time Mr. Gager has, but
Not much.
not much.
A little over a minute.
All right, thank you, Your Honors. This issue, I've been law director in Avon since 2002. So that's quite some time, 14, 15 years. I don't know your backgrounds, I'm sure that, before you became Court of Appeals judges, perhaps you were involved in some political activity, perhaps maybe one of you have been a law director in some community, but I'm going to tell you that what we do as law directors, what we do as local city legislatures is very important to the community, and it forms a basis for a lot of things that can happen in a county, in a northeast Ohio area, in the state of Ohio. And what we did here was we took a statute that was very plain and simple for me to read and for other people in our city to read, and we applied it, and we used our best judgment and applied a 3% bed tax to promote Ohio, to promote Northeast Ohio, to promote Lorain County, and to promote the city of Avon. And that is what was done here. And I don't think the legislature would be arguing with us as to what we did in this case. I think that what we did was prudent, and I believe that this court really should consider who wrote the statute and maybe send a message back to the writers of the statute that they may need to clarify a few things, because all we did here was read the statute that they wrote and apply the additional 3% tax that 15CA010879 allow us to do. That's all I have.
Thank you, gentlemen. Thank you, each of you, for your presentations. The court will take the matter under advisement. We will issue written opinion to both sides, and do check the Supreme Court website as we post our decisions there.
All right, thank you very much.
Thank you.
Thank you.